To the camera again. Batteries went out. The judge is a supervising judge of Victorville. He is one who designates whether a matter is reset back in calendar. This case here disappeared FBI 29004 after he was convicted in the court of Judge Gibson, B1 it says on the document, which he sits now in Barstow, and they're planning on shutting down the Barstow court and in a hurry to make sure that this case doesn't get to his tenor to sit, whether they can transfer him to another court. And he was the one that convicted him, and he should be the one that sentenced him. And the very interesting part about this case, it was transferred to the United States District Court on October 23rd on the state conviction as federal offenses. But it was there was two other alternatives, is that the violation of civil rights 1983, 1985, and 1986 was the reason for the transfer in the United States District Court, where Mr. Gibson was ruling the second time for reconsideration on the state crimes, and since it was already in federal court, which made Mr. Gibson as a dual sovereignty, he had a right under 3401 Penal Code, or 18 U.S.C. 3401 is a felony. A state judge can take a federal guilty plea, but a federal court judge can't. Well, that's exactly what he did. He says, I'll tend to this matter as I get to it. That he was then a dual sovereignty conviction judge. Very rare thing that all you attorneys out there, prosecuting attorneys and defense attorneys, defenses sometimes get into this matter. Prosecuting attorneys, this is a rare treat. That I'm only a pro per, and I just tore this case from one down to the other in trying to find out. This matter was because after Judge Gibson ruled on this matter, he says that someone took the case from him, which would have been a Rule 591.1, dissolving or removing from the court calendar for a motion to take it off calendar, but it takes another rule called 560 to put it back on. The interesting part is Judge Van der Veer, supervising judge, bailiffs, he'll have to ask to retake, because it was the bailiffs in Gibson's court who were in custody of the prisoner, officer, City of Victorville Police Department, Daniel Edwin Braun, aka San Bernardino County Sheriff's Department deputy, and that was convicted. And the court officers, the bailiffs, were U.S. Marshals agents at the time that when the stranger attorney, Mr. Tomlin, stated that the case had gone to federal court, automatically made the bailiffs U.S. Marshals on the reconsideration for taking into consideration reconsideration of the federal crimes that are not mentioned in the docket sheet compliments of the district attorney at the time. This goes back to June of 1989, when the Daily Press newspaper boy found that his client in apartment number 24 was trying to set him up in the drug business at 14, which is a major felony for the dealer in apartment 24. There's another long story to where this gentleman's name could be found. We won't have it here. But Mr. Braun was the one who falsely arrested me when I went into apartment 14, where Braun and Deputy Morgan and Deputy Bethke and another couple other deputies had been using this as a crash pad, and asked him if they were going to arrest this man. And the Braun and Bethke and Morgan all chimed in that they don't do arrest on people in their same apartment complex where they live. And after that, we went to the California Department of Justice and U.S. Department of Justice and DEA, who turned around and fishtailed this thing back to the City of Victorville Police Department, aka sheriffs, who faked a raid on July of '89 on 5 apartments. One of the apartments belonged to an Air Force officer. Later in another video you'll see this part. And there was no search warrants for 5 apartments, which is 469 U.S. 470, or is it 475 U.S. 469, Pembroke versus the City of Cincinnati. something like that. Any way, shape, or form, this case I was arrested on one day falsely. I proved that it was false. That's why Mr. Braun was charged with a felony. He falsified a citizen's arrest form, typical way the police departments. It's called a Penal Code 9 crime tort. False arrest carries with it its own tort. Most attorneys will get you off on the false arrest, but they will walk away from trying to prosecute the tort part because they have to sleep at the courts. So therefore they don't want to mess their sleeping arrangements up with the courts with other cases. So they don't do that, and they'll send you to attorneys who very rare they take any of these cases because it's a cozy situation where the officers of the law, the court officers, are treated differently. If you'll see this case here, it's 19 years old. He's never been retaken from his thing. He was, after conviction, a California U.S. conviction, we'll go to California, he was allowed to keep his badge, his gun, and his uniform and his authority. He retired as a California U.S. felon. He went to work for the California Attorney General Jerry Brown as a California U.S. felon. He committed felonies in Mexico, where he's wanted now, because none of the agencies in the United States have put out a warrants on him. Mexico's warrant for fugitive that is more priority because they are the only ones that's got it on paper. Everybody else has ignored this. The sheriff, Mr. Hoops, just retired real quickly to jump out of the conspiracy that he's involved with. Chief of Police Yoder, who's, when a fugitive comes available in his community, he's supposed to put this on TV and radio and everything else, naming where he lives. He lives in Apple Valley. He's never concealed himself. He's got a job as a felon, and everybody knows he's a felon. Everybody tells you, well, there's no arrest warrants issued on him. When a person is rescued from a conviction, and which puts him in custody and confinement of the courts, he should have been booked, fingerprinted, and mugshot, and got new clothes, turned it, and they taken his badge and his gun. Never happened. None of those things. And instead, a judge issued some kind of ruling somewhere, not connected to Mr. Gibson, to remove this case from the court, criminal sentencing 20 days for Braun to have gone. No appeals have been done by anybody. He's still available within 20 days of being retaken to be resentenced, but Mexico's got a priority in this matter, so he could probably be resentenced in this state along with Mexico, who's got a higher priority, and they have higher to hold on him than, and I'm the one who put the one in Mexico, and that was because in 2010 he put a gun in my face and attempted to kill me. And if he'd have pulled the trigger at that moment in time, a Mexican army troop carrier dropped all those soldiers with these automatic weapons right behind on the side of my car in the middle of the street, and he split down the street. He came down the street with a piece of paper looking up at the addresses on the building, and the addresses that he required was from a wiretap of the man who made the phone call to me. So they found out where the address phone came from. Wasn't his. He was using somebody else's at the time. So he was looking for that address when he saw my car, which was parked in front of that address. It was the only space available. So that's how that went. And in 2011, he tracked me down through the same phone number, through another phone number, to another place, and he threatened that person who recognized him from being at the scene of the first attempt. When the army officers were there, nobody could speak English. He could speak English and Spanish, so that's no problem for that department. There was two other people who were there that spoke Spanish but not English, but they understood English. So the wants and warrants for Mexico still are good. Right now, the question is whether Judge Vanderveer is going to order his own bailiffs to go take out into Apple Valley and pick up Mr. Braun, who has made no attempts to hide himself. Tanya Braun reads on the docket sheet of the false arrest by Judge Fowler, Commissioner Fowler. I was brought into the courtroom and arrested immediately after the bailiff sent me on a wild goose chase to get records, and because I was delayed by the bailiff, the judge says I was failure to appear on 8:30, so he booked me into the jail and arrested me. Then they say they lost my booking papers, and there was people in the jail that I know, and a lot of street people, and a gentleman from the high school who got falsely arrested himself, and it was interesting how that went down. But the courts on this false arrest in the city of Victorville instigated the false arrest so I would be there. These two charges arise from the fact that they have not paid their judgment to me, which was Judge Fleury was the judge that had the demand issued. This is called a PC 510, debt as a subject of embezzlement if it's been delivered. Well, my attorney who got the criminal conviction booked and then split on August 28th was the one who gave on June 26th the demand to the city of Victorville for $1.9 million plus minus a couple